Okay, good morning everyone. Uh,
Doktor dah balik Malaysia dah.
dah. Dah balik Malaysia. So you all duduk rumah je lah Ada tak siapa-siapa kat kampus?
Ada doktor, setahu saya ada lagi yang masih dekat kampus.
Oh, so you all duduk kat kampus sampai habis semester?
Saya
Maybe a
doktor.
few tu sampai PKPB je kot.
Ha? Sampai PBB lepas tu balik rumah?
Saya tak pasti.
UKM
Ada yang
bagi,
sampai habis semester, doktor.
UKM bagi duduk dekat hostel dekat UKM
Ya, sebab dah buat permohonan melalui PPP.
Oh, okay. Saya rasa kalau siapa macam especially siapa yang ada masalah internet kan, saya rasa boleh kot. Saya tak tahu apa-apa sekarang ni macam mana. Tapi macam we all tak boleh pergi office. Kami kalau nak pergi office kena minta kebenaran. So we all semua duduk rumah lah. Okay. So macam mana you all dekat rumah? Belajar okay?
Alhamdulillah doktor, semalam baru kena meja.
Semalam baru keluar apa?
Alhamdulillah doktor.
Semalam kereta. Kita tunggu sekejap tunggu the rest masuk sebab saya cakap itu 8 suku kan. Kelas tu dah start
Dah. Kelas apa, Prof? Kelas apa?
Kelas you all lah.
Oh ya. Yang macam hari ni lah first class. Semalam.
This week ni first class?
Bukan. This day.
Saya pergi kelas masters pun dah start last Tuesday.
Master pun start minggu ni lah.
Ada yang start minggu lepas tapi sebab kelas saya hari Selasa jadi Isnin tu briefing. Lepas tu macam diorang belum settle down dengan budak-budak baru especially diorang tak register dalam email diorang lah, UKM folio semua, so saya start this week.
Student dia orang full student ke yang dah kerja ke macam mana?
Ada full time, ada yang part time.
Part time sama sekali ke dengan full time belajar ke lain-lain?
Sama,
Oh.
sama kelas. Sama kelas dengan kita.
Jadi apa beza dengan full time dengan part time? Sekali je.
Part time dia satu semester ambil 2 subjek je.
Oh. Oh.
Lepas tu dia punya tempoh macam you on 4 tahun kan. Masters kalau full time 1 year. Kalau part time you boleh 2 years sampai maybe 4 years. Kalau full time dia ada maximum period dia lah. So kalau you lebih pada maximum period you kena mohon nak sambung belajar. Kalau dia tempoh tu lah yang bezakan tu.
Oh.
Tapi kalau kalau PKP punya student dia kita kena buat weekend macam tu. Weekend atau lepas office hours.
Ya, selalu macam tu juga saya dengar. Untuk ada program master dia punya kelas malam kan.
Malam. Dah beza dia. Tempoh lah, tempoh masa. Berbeza. Berapa orang dah masuk ni saya tak nampak lah kat sini. Sekejap.
103 doktor setakat ni.
Macam hujan je.
Hujan. Kat sini hujan.
Oh, saya baru habis.
Hujan ribut yang suddenly. Angin kuat. Student FUU ada tak yang sakit? Yang you all tahu? Setakat ni.
Balik mana tu doktor?
Bukan balik, sakit.
Sakit.
Tak ada kan?
Pagi hujan.
Sakit COVID je ke maksud doktor sakit apa-apa je?
Sakit COVID lah.
Alhamdulillah tak ada lagi doktor.
Okay lah, good lah. You all take care lah
Teruskan takdir lah.
Sebab apa? Sebab
Ada batch lain ada ke?
tak tahu, saya tak ada dengar. In fact staff pun tak ada saya rasa. Tapi yang dekat FST tu saya dengar, tapi saya tak tahu lah apa result dia, tapi dia ada close contact kan. Tapi kat Bangi banyak dah sekarang.
Oh.
Dulu
dekat KNS.
kan restoran tu kan. Dulu minggu lepas diorang semua takut dengan saya sebab saya duduk zon merah. Tu sekarang diorang banyak kes kat Bangi.
Oh, dekat Petaling
Saya kat Petaling. Saya kat PJ. Lepas tu dekat rumah saya ni dulu ada satu kluster. Kluster Sungai Way tu kat rumah saya dulu.
Itu yang asal-asal yang merahnya dekat bahagian sini.
Itulah. Masa saya pergi office pun semua takut. Saya kata siapa nak datang jumpa saya kena pakai mask. Masuk bilik kan. Tapi tak apalah, kita berjaga-jaga je lah. Okay, anyway, dah berapa orang? Kalau dah ramai kita boleh, semua dah ada, kita boleh start.
105 doktor.
Oh, ada lagi. 100 berapa?
27.
27? Okay. Kita tunggulah nanti Kang marah pula saya start awal. Okay, borak-borak dululah. Saya try buat kelas cepat lah supaya you all pun tak lama online kan. Lepas ni you ada kelas lagi ke?
Ada tapi pukul 12 lah.
Okay. So saya akan buat as fast as possible. The lecture. Saya ada post video dekat UKM Folio. Lepas tu saya ada letak sikit bahan untuk you all refer lah daripada Halsbury. Bahan tu dia akan sentuh topik yang semua topik saya lah 3. The first 3 topics tu which is introduction today, Lepas tu reception sikit dan juga magazine. So you can read that one as a background reading. Itu daripada Halsbury Laws Malaysia. Lepas tu you baca, you tengok video tu. Video tu is a summary of today's lecture. Okay, summaries of today's lecture that I found dekat internet that you can watch and mungkin boleh faham sikit lah kan kenapa wujudnya equity. Lepas tu as I mentioned just now dekat awal-awal tadi, kita start tutorial next week. Nanti last slide saya ada satu soalan. Jadi saya nak bincang untuk minggu depan history dalam kelas history dan juga soalan yang saya post dekat last class tu lah. Okay, untuk tutorial kan last week kita briefing. Bila kita briefing, kalau you all tengok exam 60% kan. Lepas tu kita ada 40% of continuous assessment. Okay, so saya pun tak ingat, 30 tak ada performa tu. Tapi anyway, each of us ada 10 markah kan. Lepas tu, so saya nak you all dalam kumpulan tutorial tu, you Rachel, sebab saya tak tengok lagi kumpulan tutorial tu berapa orang, satu grup berapa orang ya? Rachel, tak dengar.
Ada yang 26, ada yang 25.
Okay, so maybe you all boleh nanti dalam each of the tutorial group divide yourself into 5. You all susah ke bekerja berkumpulan? Sebab saya tak nak you all terlampau terbeban dan dengan kerja continuous assessment ni. Saya tak nak buat, therefore saya tak nak suruh you all buat individually. Tapi kalau you rasa susah, you prefer to do it sendiri, then you let me know lah. Macam mana? Ke you all nak bincang dulu apa saya nak buat untuk my assessment yang 10 marks tu ialah you come up with a poster. Nanti saya akan bagi topik for each class. Saya akan bagi topik, a few topics. So you come up with a poster. So it's up to you. Kalau sebab saya ingatkan work in group. So you all tak payah buat sendirilah. Tapi kalau you rasa online nak work in group susah, you all bincang among you all, come up with a conclusion lah. You all nak work as a group or you want to send it to me as an individual work. Then nanti you all let me know. Boleh? Boleh tak?
Boleh.
Ke nak saya bagi, ke you all tak, sebab kadang-kadang sebelum ni punya batch, diorang tak suka, dia kata nanti diorang tak boleh come up with a conclusion lah, gaduh lah itu ini. So dia kata baik doktor cakap je. So saya tak tahu, tapi sebab saya kalau face to face senang saya nak impose, tapi saya tak tahu apa you all punya challenges as nak buat online ni. Kalau it's too difficult for you to get together, then you do it individually. But if you feel that it's okay, do it in group. I prefer to do it in groups lah, sebab saya tak payahlah nak tengok banyak sangat kan. Tapi you all bincang and then let me know lah. If you cannot come up with a conclusion, then Rachel, you let me know.
Okay, Doktor, sure.
Boleh?
Boleh, Doktor.
Okay. Okay, I see we can start. Okay, I will share the slides first. Okay. Assalamualaikum. Good morning to everyone. Okay, this is our lecture, first lecture for this semester. And saya akan mulakanlah lecture untuk subjek ini untuk semester ni, dan saya akan bagi 3 lecture lah. This topic, introduction, next week reception and also maxim. Okay, untuk hari ni kita akan tengok history lah. Why history is important? Because history ni dia penting sebab dia ada kaitan dengan nature of equity tu nanti. Sebab equity ni kita nak kena faham kenapa dia wujud, supaya kita faham kenapa karakter equitable remedies, equitable concept, principles tu sebegitu. Okay, so untuk faham kenapa dia begitu, dan bila you nak aplikasikan konsep equity ni, you know kenapa you akan baca kes-kes tu dan you faham kenapa mahkamah decide sedemikian, because it goes back to nanti the reason why equity tu was developed in the first place. Okay, so objektif untuk hari ni kita akan tengok macam mana dulu di England, how equity developed. Okay, why, what was the reason behind the development of equity, and kita therefore understand the nature of equity. Okay. Okay, what is equity? Okay, kalau sebelum kita mula, kita mesti tengoklah. Okay, of course when you want to discuss anything, first thing is what is that particular thing that we want to discuss. Kita selalu tengok, kadang-kadang kita tengok, okay, literally certain things, the literal meaning is something, and then from the legal perspective is another. Okay, so what is equity? Literally kalau kita lihat, equity tu dia sinonim fairness. Literally fairness, justice. Okay. Tapi dia punya Latin word, it comes from the word aquitas. Aquitas kat sini bermaksud justice, equality, conformity, symmetry or fairness. So literally it means fairness or justice, and the Latin word refers to aquitas. It comes from the Latin word aquitas, which refers to justice, equality, conformity, symmetry or fairness. Okay, so in other words, it's fairness between individual. Okay, tapi kalau that is the literal meaning. Kalau you tengok equity dari perspektif undang-undang, from the legal perspective, equity kat sini dia merujuk kepada body of rules. Okay, is a body of rules yang which is developed dan applied by the Court of Chancery. So bila you cakap pasal equity from the legal perspective, orang akan straight away, oh, equity ni merujuk kepada that body of rules which previously was developed and was applied in the Court of Chancery. So that is what equity is all about. Okay.
Maaf doktor.
Ya?
Doktor belum rekod.
Saya dah rekod lah. Tak rekod?
Oh dah.
Dah.
Okay.
Dah rekod dah.
Alright, masih doktor.
Dah rekod. Okay. Okay. That is equity. Okay. Equity, bila kita cakap pasal equity, kita akan rujuk pada equity in reference to, sebab kita punya background, kita follow English kan. Sebab itu nanti kita punya next week punya tu kita tengok macam mana equity masuk ke dalam kita punya sistem perundangan. Tapi it doesn't mean that equity ni tak exist in other system of law. Okay. Contoh, saya bagi satu contoh lah. Equity in Roman law. Okay. In Roman law, equity is a set of legal principle which is able to supersede the rigidity of the law, and the office of praetor was responsible for the infusion of the principles of equity into Roman law. Okay, praetor kat sini rujuk kepada magistrate or council. Okay, yang dia akan function dia is to administer justice lah in the city. Okay, in that perspective, sebab dia kata equity ni managed by the praetor. Kalau kat sini saya tulis tu note, the equity in Roman law was administered by the same tribunal, therefore there exists almost complete fusion of law and equity. Okay, saya letak note tu sebab nanti towards the end ada perbincangan berkenaan dengan fusion of law and equity. So you can relate back to this slide. Okay. Sekarang kita tengok equity by juris lah. Okay, ada macam-macam juris, scholars that define or write about equity. Saya akan tunjukkan Aristotle for example. Dia kata that which is equitable is just, not legally just, simply a correction of legal justice. This is so because law is universal, but it's not possible to make universal statement about things. When the law makes a universal statement and a case arises out of it, which is not embraced in that statement, it becomes right when the lawmaker falls into error by oversimplifying the correct mission. This is the nature of equitable. To correct the law where, because of its universality, it is defective. So kalau you tengok from this, the last few sentences tu dia kata, this is the nature of equity, to correct the law. Okay, so you put that in your mind. Okay, that is the nature of the equity. Kenapa nature dia ialah when the law becomes rigid, equity will step in to correct the law. What it means by to correct the law, bukan dia baikikan undang-undang tu, tapi dia akan step in untuk make sure that the parties get justice. So that is what it means by equity kat sini. Nature dia ialah to correct the law where because of the law's universality it is defective. Not to say defective to in macam kita refer to defective goods, but sometimes the law becomes a bit rigid. Okay, therefore equity will step in to assist the plaintiff. Okay. This is another definition. Dia kata in some cases it's necessary to leave the words of the law and to follow that which reason and justice requires, and to that intent equity ordained. That is to say, to temper and mitigate the rigor of the law, and such an equity must always be observed in every law of man. And the wise man said, be not overmuch legal, for extreme legality does extreme law. Again, dalam kat sini dia kata, they mention pasal the rigidity of the law. Dia kata, be not overmuch legal, for extreme legality does extreme wrong. If you depend too much on the law, the legality of the law, it will do wrong. Sebab kadang-kadang kalau you all perasan, you all dah ya kan, kadang-kadang you baca kes-kes tu, patutnya the plaintiff or defendant lah kata, whichever party lah, sepatutnya is a clear cut case, dia menang. Tapi on grounds of technicality, dia kalah. So that's an example, okay, of rigidity of the law lah. Example. But I'm not saying that the case is wrong, but that is an example. Any body of rules existing by the side of the original civil law founded on distinct principles and claiming incidentally to supersede the civil law in virtue of a superior sanctity inherent in those principles. Okay, sama. So this definition, they go on the same breath. Dia semua cakap equity. Kenapa equity step in? Because of the rigidity of the law, because of the generality, universality or defectiveness of, not defective, there's no such word, but so-called defective nature of the law. Okay, so those are what jurists has said about equity. This is also another one. I'm not going to read lah. You all baca Dia kata kat sini no equity is no part of the law but moral virtue which qualifies moderate reform legal. Semua ni they are explaining kenapa what is equity, what's the function of equity, nature of equity, semua kat sini. Okay, kalau you tengok the last sentence of Lord Cowper ni in Dudley and Dudley, dia kata kat situ equity therefore does not destroy the law nor create it but assist. Okay, so dia tak destroy, dia cuma nak assist the law. Alright. Okay. Sekarang kita, itu definition. Sekarang kita lihat kenapa, adakah equity ni memang wujud, macam mana dia, kenapa dia wujud. Okay. Kalau you tengok history, you can read a very detailed history if you want to, but generally history dia ialah kalau you tengok kat situ prior to the 11th century, ni dekat UK lah, kalau you are interested you can read on English legal system. Alright. So I think dia quite similar dengan masa you belajar kita punya dulu Malaysian legal system kan, kita ada customary law, court, public court semua kan. So it's quite similar. It started off with custom. The custom developed into a legal system and then legal system becomes common law. Then you have the common law. Okay, so of course the common law and then of course the crown is on top as the king is on top besides things kan. So dekat sini dia kata kan prior to the 11th century there was no developed legislation judicature, instead a system of custom was applied. Justice was at the time the prerogative of the crown and this became the foundation of the emergence of the common law. Okay, saya rasa kat most legal system this is the basic lah selalunya. The focus of the common law was the cura regis, which is the King's Court, okay, and a coherent system of English law deriving ultimately authority from the king was produced. And by 1234, two common law courts, the Courts of Common Pleas and the King's Bench was developed, right? So this is a bit of history. So cura regis, what is a cura regis? It's an English court which assumed this name during the reign of Henry II. It was curia or aula regis because it was held in the great hall of the king's palace and where the king for some time administered justice in person, but afterwards the judicial power was more properly entrusted to the king's judges. The judges who sat in this court were distinguished by the name of the justiciaries. Besides this, the chief justiciary, the steward of all England, the chancellor, the chamberlain and the treasurer also took part in the judicial proceedings of the court. Okay, so this is a short explanation. So chancellor, who is the chancellor? Chancellor is the most important person next to the king. So the chancery therefore issue royal writs which became an action at law. Okay, so this is saya ambil contoh gambar royal writ. Okay. Okay, in 1258 the provisions of Oxford forbade the issue of new writs without the consent of the king in council. Thus a plaintiff with a cause of action which did not fit one of the existing writs would have no remedy in the common law courts. As a result, the common law became rigid and the rules operated unjustly. So, writ, action and remedy. A royal writ was needed to start an action. Okay, the types or numbers of writs was limited. So the common law remedy was limited to monetary damages. The effect of this is the plaintiff's action and remedies available were limited. Common law was therefore regarded as rigid and inflexible. So what happened was, okay, kita ada king, lepas tu king of course dia bagi kuasa dia dan chancellor macam saya cakap tadi. So what is the relevant of this writs? So bila you nak start an action, your action must fall within the categories of the writs that is being issued. So kalau apa-apa tindakan you tak boleh fall within that particular writ, okay, then you cannot bring your action. Okay, that is one. So what happened is banyak plaintiff yang dia ada they want to bring an action tapi they cannot because the common law writ was limited. The types and number of writs was limited. Therefore, this cause injustice lah kan, sebab you cannot bring your action because your action cannot fall within the categories of the writs available. Itu nombor satu. Lepas kedua, common law remedy at that time, in fact bukan at that time lah, memang sekarang pun, sekarang sebab dah dia tak separate, okay. Tapi common law remedy, the nature of common law remedy is monetary damages. Maknanya kalau you breach something, you apa remedy you dapat? You dapat duit, kan? You nak compensation, that the other party to pay you. So that is the nature of common law remedy. So tapi sometimes the plaintiff, dia bukan nak duit, dia nak certain things being done. Contohnya injunction. Injunction dia tak nak, dia nak orang to stop doing whatever. Contohnya kan. Okay, so you want to prevent that person from continuing, macam contoh case nuisance. So you want to, you ada baca nuisance kan last year. So you want to stop that person from committing that. So you apply for injunction, you prevent that person from committing that particular action over and over again that is causing nuisance to you. So you apply for injunction, you don't want money. So common law remedy is purely compensatory. So duit, tapi kita tak nak duit. Some plaintiff don't want money, they just want a few things to be done. Contohnya injunction, specific performance. Dia nak kontrak tu dikuatkuasakan. Dia tak nak duit, dia nak penguatkuasaan kontrak tu. Therefore, you ask for specific performance. Sometimes you ask for rectification of a document. So those are all equitable remedies. So from these reasons, okay, maknanya plaintiff ada the common law at that time caused a lot of injustice because number one, some plaintiff cannot bring their action because of the numbers of writs and types of writs which are limited, and secondly, the remedies are also not suitable to certain plaintiff. So hence common law was regarded as rigid and inflexible. Okay. This slide is actually what I explained just now, is a repetition. Inadequate remedy, damages as the only common law relief will always prove to be inadequate, like I said just now. More often than not, petitioner was unable to obtain it because of the disturbed state of the country or the power of wealth of the defendant who might put improper pressure on the juries. Okay, this was history lah. Formalities. The common law paid too much attention to formalities. For example, if a contract was made which required written evidence for its enforcement, the lack of such evidence meant that the common law courts would not grant remedy. Okay, another example yang saya explain tadi lah. Okay, so the court system worked well apart from the fact that by the end of the 14th century, the application of the law had become so rigid that justice was not always achieved and the law did not provide any solution to the disputes. Okay, so the system worked well until some time. Masa mula-mula tu okay, until a certain time it became quite rigid. Okay, so what happened? Bila dah jadi macam tu, banyak tak puas hati, so they send appeals and petitions to the king. Okay, they send petitions to the king, and then king bila dah banyak sangat appeal petitions, they he let the Chancellor these petitions to be heard by the Chancellor? Okay, originally the Chancellor did not have any clearly defined jurisdiction. So dia cuma dengar je lah whatever appeals and petitions sent. The Chancellor dispensed justice remedying the common law on grounds of fairness. Okay, tengok fairness, conscience and natural justice. This refers back to the literal meaning just now. Okay. In remedying the common law, the Chancellor refused to use jurists, question the parties himself with questions of fact and issued subpoenas. In the absence of fixed principles, decision made depended upon the Chancellor's personal ideas of what is right and wrong. Okay, so maknanya dia akan decide the cases based on his own conscience lah. Okay, what he thinks is right and what he thinks is not fair, okay, or wrong. Thus, equity varied according to the conscience of the Chancellor. So, of course, bila you could decide something kan, you decide something based on your own standard, okay, your own personal conscience. So, of course, dia tak ada, bukan tak ada consistency, dia sort of tak ada consistency lah. So what the Chancellor thinks is right or where he thinks that justice will be met, so he will decide based on that. So hence masa tu there's a saying which says that equity varied with the length of the Chancellor's foot. Maknanya kat sini equity tu dia berbeza-beza according to how is the Chancellor, according to the Chancellor's view, based on what the Chancellor thinks is right or wrong. Okay, so petitions were heard in the Chancellor's office, which at the end of the 14th century evolved into the Court of Chancery. So bila dah banyak-banyak, okay, kalau you tengok similarly common law kan, which started as custom. So bila dah jadi lama-lama banyak-banyak, it developed into a court system. So similarly, untuk Chancellor ni, lama-lama it became of Chancery. Okay, so when it became the Court of Chancery, so ada Common Law Court and Chancery Court. So what happened after that? Okay, for a long time, there was close consultation between Chancellor and the common law judges as to the types of case in which relief should be granted. There were instances whereby the Chancellor sometimes sat at the common law court and vice versa. Okay, of course, bila you ada two different courts, right? Sometimes there will be conflict between these two. So therefore, there is a conflict between equity and common law. Sometimes, sebab kadang-kadang, sebab kalau you tengok pun, you tengok cases pun kadang-kadang kalau ikut law, contohnya, the agreement is not in writing. So the question is, can it be enforced? Right? Kalau you ikut very strictly, contohnya lah kalau ikut common law, agreement not writing, it's not enforceable. Lease not writing is not enforceable. But if it causes injustice to the party, now sometimes equitable principle will step in to assist where there is clear injustice. Yeah? So there is a conflict there between equity and common law. Okay, so this is a basic summary of the history that I mentioned lah. So mula-mula king kan. So the king kat sini bila ada banyak-banyak, bila the common law tak boleh address the grievances of the plaintiff, so there were a lot of appeals or petitions to the king. So when that happened, the king allowed the Chancellor to listen to the appeals. Macam saya explain tadi. So lama-lama the Chancellor had a judicial, dia pemegang peranan kehakiman. So lama-lama dia keluarkan decree di bawah namanya sendiri dan this became the Chancery Court. Like I explained just now lah Okay, so that is how equity was developed. Right? Itu kenapa equity wujud lah. Okay. So bila kita lihat from the history just now, kita dapat lihat yang the Chancery Court had certain characteristic lah. Because of the fact that due to the fact that the Chancellor decided based on what he thinks is right and wrong, it's also referred to as a court of conscience. Okay, because the Chancellor ni usually macam orang yang background agama lah. Okay, so dia akan decide what is right and what is wrong based on his conscience. So and then therefore court of conscience, therefore there is no consistency in the decision. Okay. Kemudian later on it developed into a court of, when it developed into a court of equity, keputusan mula dilakukan. Okay, and as a result wujudlah sistem judicial president. Kan, you all ingat lagi tak judicial president masa first year? Kan? So in other words, the Chancery Courts ni, okay, the Court of Chancery ni develop into a system of law. Okay, so and then after that wujud Akta Kehakiman 1873 dan 1875 dikubal. Okay, so Court of Judicature Act 1873 and 1875. Okay, sebelum Akta Kehakiman 1873 dan 1875, kita lihat di sebelah kiri saya tu, dia kata ada Chancery Court, ada Common Law Court. Okay, so Chancery Court ada bidang kuasa equity, Common Law Court ada bidang kuasa common law. That means, what it means was, kalau saya, contohnya saya nak bawa tindakan dan saya nak dapatkan remedy common law, saya kena pergi mahkamah common law. Okay, to get that. I cannot go to the Chancery Court to get a common law remedy, so I have to go to common law court. But if I want to get common law remedy and equitable remedy, I have to go to both courts. I have to go to Chancery Court, I have to go to common law courts. So that, when that happened, it created a lot of tension between these two courts and also inconsistency and conflict. Okay, sebab you imagine you have to go to two places to get one thing, kan? So therefore adalah Akta Kehakiman 1873 and 1875. Okay, what this Court of Judicature Act did was dia restructure the court system. So there's one court, okay, and of course there's High Court, Court of Appeal, and then High Court is divided into a few divisions. Okay, there are the Chancery Division. Okay, dulu it's called King's Bench, but now it's Queen's Bench. Okay, so dulu dia ada King, sekarang ada Queen, I suppose lah. Then dulu it was called Probate, Divorce and Admiralty. Now it's the Family Division, right? So what happened with this restructuring was that now you don't have to go to two different courts to file your suit. You go to one court and the court can listen to all your grievances, okay, whatever you want. So you apply kat satu mahkamah, you can get both common law and equitable remedy. Itu in terms of remedy. And also in terms of what to, macam tadi kan read tu kan, masalah kekurangan read, okay, types of reads tu. So it's is everything is in one chord. So if your action is based on equity, you go to the Chancery division. Otherwise, you go to the different division, family division ke Queen's Bench, right? So that is the restructuring of the courts after Court of Judicature Act 1873 and 1875. Okay, apakah implikasi akta ni? Akta ini mempunyai dua bidang kuasa. Okay. Seksyen 24 Akta 87 dan Seksyen 49 1 Akta Mahkamah Agung 1981. Okay, these two provisions dia kata tidak seorang plaintiff tidak perlu membawa tindakan berlainan untuk mendapat relief ikuti. Okay, so macam saya explain tadi. And apabila ada konflik between equity and common law, equity will prevail. These the provisions yang ada ke atas tu, it deals with these two issues. You don't have to bring to a different court, and if there's conflict, equity will prevail. Okay, similarly kalau you tengok kita punya section 3.2, kalau you boleh recall lah masa of first year. Seksyen 3.2 Akta Undang-Undang Sivil kita pun kata sekiranya ada konflik between equity dan common law, equity will prevail. Okay. Okay. Kita ada mula-mula is two different courts, two different system, and then dia cantum. Lepas Akta 1873 dan 1875, kesan dia pencantuman between common law and equity. So bila ada pencantuman ni, ada banyak-banyak pendapat keluar. So ataupun persoalan lah, bukanlah persoalan, discussions, scholarly discussions. So the question is, with the Court of Judicature Act 1873 and 1875, is there a fusion of law or a fusion in administration only? Maksudnya, adakah pencantuman tu kesan dia mencantumkan dari segi aspek pentadbiran common law dan equity sahaja, ataupun dia mencantumkan secara am, okay, in substance, common law dan equity. Okay, dua pendapat ni. Fusion in administration or is there a fusion in substance? Okay, apa maksud fusion in pencantuman pentadbiran? Okay, fusion of administration, or rather the traditional view. There is no, what this view says is that there is no fusion in substance or no fusion in law. Okay, sebab dia kata professor, based on Professor Ashburner's view, dia kata there's two streams of jurisprudence, though they run in the same channel, run side by side, and they do not mingle their waters. Maksud dia kat sini, you have common law, you have equity. Walaupun common law dan equity now is managed by one court system and they run side by side, tapi they are still different. Okay, itu pendapat pertama. Those yang for fusion of administration. Okay, dia kata tak ada fusion in substance or fusion in law. Dia kata it's only fusion in administration. So dia kata because common law is still common law, equity is still equity. They are managed in one system of court only. They do not mingle. Okay, still there is still a difference between common law and equity. So this view was also expressed in Salk and Cooper. Okay, case lama sebab this is history 1880. Salk and Cooper dia kata the main objective of the act was to assimilate the transaction of equity, business and common law business by different courts of judicature. It has been sometimes inaccurately called the fusion of law and equity, but it was not any fusion or anything of the kind. It was the vesting in one tribunal of the administration of law and equity in every cause, action or dispute which should come before the tribunal. So what Salk and Cooper say is inaccurate. Maknanya tak betul lah you kata there's fusion of law and equity, because they kata it's just you are just administration, it's just the administration of these two different system. Yeah, therefore so much so that you can go to one court and you can get both. That is what Salk and Cooper is trying to say. There is no fusion of law and equity. Law kat sini dia refer to common law lah Sebab you kena faham saya pause kejap pasal slide ni sebab ada saya ada satu student dulu lah, seorang student yang penerima anugerah jugalah Masa dia jawab first semester ni, dia confused sebab dia kata bila dia cakap law kat sini dia fikir law tu as law in general, right? But kat sini law is not law in general. Law is referring to common law. Okay, sebab we are discussing common law and equity. And also bila you kata bila you discuss especially first semester because kita belajar pasal common law and equity ni, bila the court says law, you kena tengok dia kata law tu dia merujuk pada common law, dia merujuk kepada undang-undang apa, walaupun cases kita you kena dengar saya tak? Hello, dengar saya tak?
Dengar.
Okay, sebab saya suddenly dia kata hold on, we are trying to put you back in the meeting. So saya ingat saya cakap seorang-seorang. Anyway,
Baru stop dekat
so bila you kat mana?
dekat the law yang
I
disebut.
stop tak? Okay. So bila you bila you cakap pasal law, you kena tengok law in what context. Even cases kita pun you kena tengok balik. Law tu law in what context dia cakap. Is it referring to common law and equity punya law ataupun law in general? So bila you jawab soalan pun you kena be careful. Bila you kata law, apa maksud you? Sebab common law and equity is not the same. Okay? Common law principles are not the same as equitable principle. So itu yang kita tengah bincang ni, fusion tu adalah fusion tu law, fusion of law and equity, or is it is law and equity now one, therefore bila you cakap pasal law it's understood it's law and equity. Tapi kalau you tengok case-case juga, kalau you tengok case-case even sekarang, especially in granting equitable principles, the court still will highlight that the nature, contohnya, nature of equity is to prevent injustice dan semua. So they still go back to the reason why equity came into being. Okay? Okay, so back to just now, fusion of law and equity. Tadi kita Sok and Cooper kata there's no fusion of law and equity. So in other words, what this view represent was that fusion of administration simply means that law, common law, and equity is no longer administered by different courts, so much so that if a plaintiff could not get relief in one court, he would not be sent or he would not be sent or has to go to another court to get relief. Okay, sebab dulu kalau you nak common law relief, you have to go to common law court. But if you also want equitable relief, you also have to go to equitable court. Contohnya, if to get things clearer, kadang-kadang you nak orang tu, katalah contoh saya bagi super macam nuisance lah. Your neighbor cause nuisance to you. As a result of his action, you also suffer a little bit of damage. Okay, so you nak apa? Remedy you nak dia tak nak dah dia buat whatever, katalah dia buat construction, rumah you retak. Contohnya and construction tu cause also macam noise ke whatever. So you want him to stop, but you also want him to pay damages for the damage that you suffered as a result of what he did. So kalau dulu you have to go to two different courts. Okay, you have to go to common law courts to get the damages. You also have to go to equity chancery courts to get injunction. So now, fusion of law and equity, by virtue of the Court of Judicature Act, you go to one court to get both. Okay, so this is what is trying to say lah. The first view kata fusion of law and equity tu is just administration and nothing more. That means you go to one court, you get both. Okay. Okay, another view is that no, dia kata bukan, this is it's wrong to say that there's only fusion in administration. There's also fusion in substance. So Walsh and Lonsdale, the court in Walsh and Lonsdale stated that there is only one court and the equity rule prevails in it. Okay. In 1978, Lord Diplock commented on Ashburner's view, which is the traditional view. In the case of United Scientific Holding and Burnley Borough, where he said, by 1977, the metaphor has, in my view, become both mischievous and deceptive. The innate conservatism of English lawyers made them slow to recognize that by the Supreme Court of Judicature Act 1873, the two systems of substantive and adjectival law formerly administered by the courts of law and courts of chancery were fused. If Professor Ashburner's fluvial metaphor is to be retained at all, the waters of the confluent streams of law and equity have surely mingled now. So, Lord Diplock in 1978, dia tak setuju. Dia kata, no, dia kata it's not. Because we do not differentiate anymore between common law and equity, in the sense that you don't say, oh, this is common law remedy, this is equitable remedy. No, dia kata tak. Memang dia kata it started off two different things, two different nature, but they go back to the tadi yang two streams of law tu kan. Tapi dia kata stream of law tu dah sekarang mingle together and there is the fusion in substance, dia kata. Okay, in aquaculture, in other Commonwealth countries, fusion in substance has been more readily accepted. Okay, macam kita lah, for example, kita tak discuss or go deep on this fusion thing because we are actually on the receiving side. Okay, but in the country where it first originated, previously there is discussion that about this fusion between common law and equity. But of course, in other Commonwealth countries, macam dia kata, fusion in substance has been more readily accepted. Okay, in New Zealand, Court of Appeal, they address the question whether damages, which is historically a common law remedy, should be available as a remedy for breach of an equitable duty of confidence. Okay, and in that case, the court said that for all purposes, now material, equity and common law are mingled or merged. The practicality of the matters is that in circumstances of the dealings between the parties, in the circumstances of the dealings between the parties, the law imposes a duty of confidence. For its breach, a full range of remedies should be available as appropriate, no matter whether they originated in common law, equity or statute. Okay, so this is the Commonwealth countries punya most dia punya approach lah ya. Okay, so conclusion, this is my last slide. Like I mentioned just now, I'm going to give you a question. This is the question. The conclusion ialah sama ada in your opinion, there is no right or wrong answer. Okay, in your opinion, it's a matter for discussion. Is there a single coherent body of law? Is there a fusion in substance or just fusion in administration between common law and equity? So untuk kita punya tutorial minggu hadapan, okay, saya nak kita bincang ni. Okay, apa pendapat you all? Okay, sama ada pada pendapat you all fusion tu fusion in substance ataupun fusion in administration saja. Okay, sebab isu dia timbul kat sini ialah kena isu fusion ni timbul because bila you tengok kes-kes, okay, even sekarang ni, okay, but especially cases yang discuss a lot, okay, on the application of equitable principles, they still pendapat-pendapat yang selalu macam apa timbul this discussion is that because they say that, you know, the court still differentiate between equity and the law. Okay, equity and the law, or equity and common law kalau kat UK. Okay, so therefore there is no fusion in substance because of the differentiation. Okay, so my question is for us to discuss next week. What is your opinion? Do you think that there's only fusion in administration, or do you think that there's fusion in substance based on what happened and based on the Court of Judicature Act? Okay. So any questions? Okay, saya tengok conversation.
Doktor, salam doktor.
Waalaikumsalam.
Nama saya Haziq, saya ada soalan berkaitan dengan tutorial. Untuk tutorial nanti kita perlu prepare slides apa-apa ataupun just a mere discussion?
Next week kita mere discussion je lah. Tak tahulah kalau you all rajin, siapa-siapa rajin nak bagi slide, kita boleh tengok. There's no harm. But I do not require you to prepare lah. But if you want to prepare, if you want to come with a slide, kalau you nak, you can prepare. But I don't require you lah kalau you tak nak. But if you have, you can. Does that answer your question?
Yes, Doctor. Thank you.
Okay. Any other question?
Doktor,
Aha.
saya ada soalan yang slide sebelum slide mana tu yang sebelum equity dipisahkan dengan tu yang kan ada gambar pajah tu. Sebelum equity dan common law dipisahkan ada yang ni kan. Ada soalan tentang tu, tentang slide tu.
Sekejap. Sekejap. Saya macam ada masalah teknikal sikit ni. Sekejap. Kat mana? Dekat mana tadi?
Dekat olah. Macam mana ni?
Ha? Kat mana?
Ni.
Ni?
Kejap. Yang bukan. Alah. Bukan. Ada
Tak apa-apa. Yang mana satu you cakap saya?
Ni. Akta Hakim Malam Maksud. Ni. Ni kan doktor.
Yang ni?
Selepas ni kan maksudnya Chancery ni ada bidang kuasa equity dan common law sekali ataupun Mahkamah Tinggi ni ada macam dimasukkan tiga ni macam mana cakap?
No, okay. Maksud dia kat sini, mahkamah dia ada Court of Judication Act, that means you have high courts with different divisions. You have high courts with different division. Lepas tu you have high court with different division. Lepas tu division tu dia ada Chancery, Queen's Bench, Probate contoh ya. Chancery, Queen's Bench, Probate which became family, right? So maksud dia kat sini, katalah you punya tindakan tu adalah jatuh dia division dia adalah sekejap Amal. Okay, katalah you are starting an action, right? And you're starting an action and your action is based on common right, ataupun your action is a family matter. So you start your action in the family division. Tetapi masa you minta remedy tu, you can get both common law remedy and equity in that division. Faham tak? Tapi kalau let's say let's say you punya action tu is equity in nature, okay? Then you file your action dekat Chancery Division, but you can get both remedy from equity. You can get both equitable remedy and common law remedy. Jawab tak soalan saya? Sebab kalau you tengok soalan you. Kalau you go back tadi recall kan, kalau you nak start action, you kena start based on the different type of writs. Kalau you punya action tak jatuh bawah any bahagian writ tu, you cannot bring an action. Therefore start petition semua, then ada ikuti kan. So tapi these divisions are like the writs. Contohnya lah, I'm not saying that they are, but it's like the writs. So maknanya katalah case you family ataupun katalah case contract, you start from Queen's Bench, you file your action in Queen's Bench, but you want remedy, you want money and also specific performance ataupun actually specific performance dia kalau common law remedy nanti you belajar lain lah, tapi katalah you want to get both common law and equitable remedy. So therefore you file your action in Queen's Bench, but you can get both remedy. Okay, jawab tak soalan?
Jawab. Terima kasih doktor.
Yang
Ya, Aiman.
itu untuk konteks dekat UK lah kan? Kalau dekat
Dekat
Malaysia
sini
pun begitu juga. Boleh untuk
Dekat
dapat
sini pun
dua-dua.
okey lah, macam katalah you. Dekat sini pun, so ini kesan atas kehakiman bila sampai kat kita macam saya kata tadi, kita we are at the receiving point. So it's like kita ikut the development of what happened in England, right? So after this Judicature Acts, after the restructuring of the courts, this is what happened in UK. So that means there's no more two different court system. You tak payah pergi two different court system. You can get both from one court. Okay, both remedy lah. Actually ni is both remedy, right? And also kalau you punya heading tu you tak jatuh bawah mana-mana, mungkin you know is a more spread system, that in the sense that you boleh file kat mana-mana division, right? And get both remedies. So kat Malaysia pun kalau you tengok it's the same thing. Kan, you tak pergi mahkamah, there's no chancery court in Malaysia daripada dulu sampai sekarang. Ada ke you belajar dulu masa tak ada kan? So kita ada sistem kita pun sama, magistrate, session, high court kan. Lepas tu it's the same thing. Dia punya dekat Malaysia pun tak ada perbezaan antara mahkamah tersebut sama ada you nak dapat remedy common law, you kena pergi specific court ke tidak, tak ada. Tapi of course kita punya division bukan macam ni lah kan. Kita tak ada chancery kat sini, kita tak ada Queen's Bench. Kita mungkin ada apa division of courts. Kita you belajar dulu MLS. High court kita ada division dia kan. Ada commercial division, ada apa family division.
Muamalat.
Sebab sekarang dia dah banyak-banyak dah kan. Dia dah macam rename different kan. So kita ada civil division kan. Kita ada corporate, saya tak rasa corporate and commercial. Dia ada division-division dia bawah high court kan. So similarly, tapi kita tak ada chancery, we never had chancery. So bila sampai kat kita, high court kita ada different division, tetapi kita tak ada chancery, tapi the same thing, if you have file, then you can get both. Kita tak ada chancery, kita tak pernah ada Queen's Bench. Itu semua UK. Okay. Ada lagi soalan?
Saya. Prof, dengar ke?
Ada ke?
Tak saya tanya, kan apa dia buat petition dapat kat Chancellor semua kan. Jadi daripada petition ni RIT pun ada terjejas ke? Maksudnya RIT jadi ada banyak type, jadi action lebih banyak boleh diambil ke? Macam tu.
Macam mana? Saya tak faham soalan.
Kan rakyat bagi petition dekat King, tapi kebanyakannya send to Chancellor kan. Jadi daripada petition ni kan tadi RIT tu limited, ada type-type tertentu saja, action tertentu saja boleh ambil. Tapi bila ada petition ni, adakah RIT tu lebih banyak type jadi banyak action boleh ambil ke?
Okay. Apa maksud petition tu ialah, okay kan RIT tu ada jenis-jenis RIT dia. Maknanya jenis-jenis permohonan lah untuk memulakan tindakan. So that itu yang dipanggil sebagai RIT. Okay. So bila ada jenis-jenis tertentu, tapi plaintiff ada yang tak boleh fit, tak boleh dia nak bawa tindakan tapi tindakan dia tidak jatuh di bawah mana-mana jenis RIT yang sedia ada. Okay. So dia punya tu tak boleh jatuh bawah mana-mana, so dia akan appeal. Dia akan hantar petition to the King. So mula-mula King dengar, bila dah banyak-banyak, King suruh Chancellor dengar. Itu maksud dia. Soalan you tadi apa?
Jadi read, daripada petition ni, read yang limited type dia tu, type dia lebih banyak ke?
Tak, okay. So bila dia hantar petition, dia appeal, dia kata okay, contohnya lah saya cakap in layman dia kata okay, dia hantar petition tu, dia hantar appeal lah. Appeal tu dipanggil petitions. Dia hantar petitions to the king, okay, dia appeal to the king, cakap okay, saya ada masalah ni tapi tak boleh bawa any petition. So king dengar, king decide. Bila dah banyak-banyak, dia bagi that power to the chancellor. Okay, so then chancellor will decide. Dia tak ada kena-mengena dengan read tadi. Read still remain read. Dia tidak tambah, dia tak ada kurang, dia remain read. Tapi appeals ni yang orang-orang yang tidak boleh bawa tindakan kerana kekurangan kategori read tu akan pergi kepada chancellor dan chancellor dengar. So bila dah lama-lama dah jadi banyak, it became one system of law. Itu yang jadi court of chancery. So yang read tu so remain, that is the common law court.
Okay,
Jawab tak?
Thank you, Doktor.
Faham tak?
Faham.
Okay.
Thank you, Doktor.
Any more questions? Ada soalan lain tak?
Saya ada satu soalan yang ringkas lah, Doktor. Among other things saya ada tengok yang Hasbury yang Doktor share dekat UKM Tapi lepas saya baca dan lepas saya dengar kuliah ni, saya rasa macam dengan a bit confused macam dengan apa orang cakap underlying kenapa kena separate dan semua ni. Jadi saya assume kalau saya tengok dekat slide nombor 26 yang case New Zealand tadi tu, yang fusion in substance, dan juga saya tengok adakah untuk kita tentukan whether dia fusion in substance ataupun in administration, adakah kita kena tengok adakah dia orang punya breach tu adalah breach of equity punya doctrine ataupun common law doctrine? Adakah tu satu consideration yang kita kena ambil tahu, Doktor? Terima kasih.
Maknanya dalam masa membawa, okay, soalan you on fusion ke on how the court is administered now?
Infusion.
Okay, fusion ni, the issue of fusion ni is just a discussion, okay, is a scholarly discussion, pendapat je lah. Okay, it's not something that kenapa, okay, sebab kenapa isu permasalahan fusion ni timbul, because dia timbul sebab bila dua sistem mahkamah ni wujud, okay, dan disatukan dalam satu sistem, kita lihat dua sistem yang nature dia berbeza disatukan dalam satu. So bila disatukan dalam satu sistem, timbullah persoalan sama ada restructuring of this court system ni mewujudkan satu sistem baru, okay, di mana ikuti ada common law dan equity, ataupun dia memudahkan pentadbiran kedua sistem ini ke dalam satu sistem. So kenapa isu fusion ni timbul nanti kalau you nak tengok ialah kenapa sometimes the discussion is existed, because they say that common law still remain as common law. Common law principles remain as common law, equitable principle remain as equitable principle. So and it's just in terms of administration, it is administered in one system, but it's still two different system of law. So-called system of law lah, because it originated from two different system, right? Tetapi some disagree. Some kata you cannot say that it's two different system. It's one system whereby there's common law and equity in it. So bila you go to court, there's no need to differentiate between common law and equity. If there is one law, okay, where in that one legal system, there are principles which originated from common law and there are principles which originated from equity, and the nature of these two principles differ. So one principle is there to assist any rigidity of the other principle that originated earlier. So itu isu fusion tu sebenarnya. So apa pendapat itu pendapatlah, dua pendapat yang berbeza. Okay, tapi saya dah lupa dah apa soalan yang lepas tu. Aiman ke tadi?
Ya saya doktor.
Apa
Sebab
soalannya
saya macam dengan confused lah. Macam first kali macam kalau kita tengok from historical development, dia nak mitigate harshness of common law dan semua-semua tu. Dan apabila saya macam saya pun tak tahu doktor, tapi apabila saya tengok kepada Hasbury yang Dr. Sen tu, dia macam dengan saya punya kefahaman, dia kena ada breach of common law satu, breach of equitable doctrine satu. Contoh dia macam dengan saya tak tahu betul ke tak saya punya, sebab saya tak baca full case yang New Zealand yang slide ke-26 tu. Dia macam dengan menurut kefahaman saya, dia macam dengan satu breach of common law, satu lagi breach of equitable doctrine, which is one of it duty of confidence. Yang tu saya macam dengan kabur lah untuk slide yang ke-26 doktor.
Okay, dia ni ni ke?
Ya doktor.
Okay, actually macam ni, kalau you tengok okay, issue fusion ni adalah number one is a discussion, okay, a discussion of law lah. Tapi when kita bring macam sekarang we talk about now, when you bring, sebab nanti bila you tengok topik ketiga masa kita tengok maxim, you boleh nampak lebih jelas lah. Sekarang saya nak explain, mungkin you tak nampak sangat sebab dia a bit macam a bit of jurisprudential sedikit tapi you tak apa nampak. Tapi nanti bila later on bila you tengok maxim contohnya, nanti dalam maxim tu in certain cases you can see, for example there is one case where dia ada requirement, kalau dia list it must be in writing. Kalau it's not in writing you cannot enforce. Contohnya one of the cases. So tetapi kalau kita ikut pemakaian kalau kita katalah kita put ourselves in the system yang dulu, so you cannot enforce this. Okay, tetapi the case of course the case is after Judication Act. Dia kata ya, walaupun based on common law it has to be in writing, but kalau you tak enforce it will cause injustice. So therefore equity is applied. Where equitable list is applied, writing is not necessary. Sebab kenapa dia guna pemakaian itu? Kerana dia tak nak cause injustice to the plaintiff. So therefore they use that. So bila you tengok macam tu, you nampak dekat situ yang function equity tu is to make sure that justice is served. Of course, bukan bermaksud yang kita nak destroy the law. Macam tadi kan, it does not, the equity punya function is not to destroy the law. It's just to assist the law. So maknanya, katalah orang tu sengaja nak guna equity sebab contohnya dia nak menipu. Okay, nanti dalam magazine there's another case, dia guna, itu case Malaysia, dia guna kanun tanah negara, provision dalam kanun tanah negara which says that you cannot transfer. Tapi clearly benda tu dia guna untuk to manipulate the statute to his advantage. So in that sense, and dia nak guna prinsip equity contohnya, kan? So in that sense, equity will not be applied. Because equity is not there, walaupun is allowed, but not there that's not the function of equity. So kalau nanti you tengok, you cuba baca sikit kalau you rajin lah ataupun we can always wait until magazine. You look at the cases in magazine. Okay, so you boleh nampak macam mana equitable principles is applied, especially when the law is rigid. Okay, in our context kat Malaysia, of course kita tak common law is not something that is applied widely now lah, especially now memang tak lah kan. Tapi sometimes statutes, the requirements of statute is such that it is very in certain circumstances it will cause injustice to the parties. So in that case, kalau mahkamah choose to follow the law strictly, okay, the statutory provision strictly, that it will cause injustice to the party. So this is when the courts, in certain circumstances, depending on the circumstances of the case, evidence, and also the evidence, the court will apply equity. Okay tak Aiman?
Faham.
Okay.
Terima kasih banyak-banyak.
Tak apa. Kalau you tak apa, kalau you rasa sebab kadang-kadang ni equity ni the first few lectures ni dia agak dia ala-ala jurisprudence sikit lah, tapi but as you go on you see the cases and how it is applied, you will see how actually inequity tu is now a system. Okay, and court of course sometimes will still mention that equitable principle of what? Okay, the equitable doctrine of this contohnya estoppel and all that. Those are all you all ada belajar estoppel kan dulu masa kontrak?
Ada doktor.
Kan? So estoppel is an equitable principle. So of course estoppel ada banyak jenis ya, ada common law estoppel and equitable estoppel, tapi macam promissory estoppel, proprietary estoppel, those are all equitable principle. Sebab so kalau you tengok kan, dia estoppel tu apa? Bila orang buat representation, you cannot and then the other party rely on that representation, you cannot go back and say, oh I didn't say. Katalah orang tu berhutang dengan you RM100. Atau you kata, okay tak apa, you don't have to pay me 100, you just pay me RM50. Lepas tu based on your representation tu, that person change his position, so he has an extra RM50. Contohnya apa? He use that other RM50 yang kononnya dia nak bayar saya tu, dia buat benda lain. Lepas tu saya tak boleh go back on my promise. So that is an equitable principle. Okay, tapi by right kalau ikut katalah ada contract kan between A and B tu, by right according to that contract you still have to pay me, but when equity steps in based on my representation, which is an equitable principle, promissory estoppel, you tak payah bayar. I cannot say that oh I changed my mind. Okay, I changed my mind, you pay me back 100. Tak boleh. Okay, if estoppel is applied lah. Alright, itu contoh dia lah, tapi tak apa, don't worry too much, you just read the for today you just read the history. Okay, is actually the history tu is not really important. I mean especially the part yang English history tu, tapi apa yang saya nak tekankan kat sini ialah yang penting tu ialah bila you kena faham nature equity tu. Kenapa equity tu came into being, how it came into being, kenapa dulu daripada sebelum tak ada equity, macam mana kenapa equity tu develop. Sebab bila you faham kenapa equity tu develop, baru you boleh faham the nature of equitable principle. Kenapa kita apply equitable principle. Okay?
Doktor, Prof. Equity ni dia boleh juga terpakai untuk kes kriminal ke? Sebab sebelum-sebelum ni contoh-contoh macam contoh kes civil dispute. Civil boleh tak dia terpakai untuk kes kriminal?
Civil dispute. You belajar kriminal dengan civil tu ada beza tak?
Ada beza. Tapi boleh tak macam contoh remedy injunction tu kan? Dia contoh kan kita mencemarkan air ni kira satu dikira sebagai jenayah kan? DPP akan dakwa.
Civil dispute is not the same as criminal, you know?
Tahu. Yang cuma remedy injunction tu.
Nak injunction tu you kena buat kat mana?
Oh kena tak kalau
criminal case dia pergi ke mahkamah mana?
Mahkamah jenayah.
Okey, kalau civil case pergi ke mahkamah mana? Tu je soalan saya pada you.
Civil division. Tapi di bawah mahkamah jenayah tu boleh tak hakim buat memberi perintah injunction?
You belajar tahun 2, kes-kes mahkamah ada tak dia bagi civil remedies? Saya nak tanya, saya tak nak bagi jawapan You belajar tahun 2 kan? Jenayah kan? Bawah Prosyam kan? Kes-kes kriminal ada tak diberi civil remedy? Ada tak?
Dia bagi hukuman.
Cuba tanya Prosyam. Ada ke tak? Siapa boleh jawab? Siapa dapat A, kriminal? You pergi tengok balik kes yang you belajar tahun lepas. Kan? You tengok ada tak kes-kes? Macam jenayah air semua tu kan? Jenayah apa? Kes-kes pencemaran kan? Okey. Ada apa-apa soalan lain? Dengar saya tak?
Jelas doktor.
Dengar?
Dengar.
Okey.
Dengar doktor.
Okey, ada soalan lain tak?
Doktor, kalau nak tanya doktor punya pandangan tentang fusion in substance and fusion in admin tu nak tanya sekarang ke ataupun kita bincang nanti masa tutorial?
Kita bincang nantilah masa tutorial.
Okey doktor.
Soalan yang last slide tu ya. Ni ya. Kita bincang nanti first tutorial kita bincang pasal fusion. Kita bincang pasal fusion, kita bincang pada pasal history. Alright. Okey, kalau tak ada apa-apa soalan, boleh saya stop?
Boleh.
Okay, so thank you. So I will see you next week, reception. Next week sebenarnya adalah satu topik reception of equity into our system. Sebenarnya topik tu topik MLS yang you all belajar section 3 tu. So saya rasa next week kalau saya sebab saya rasa topik tu very straightforward and you all pun dah belajar masa MLS, saya ingatkan saya nak buat terus Maxim. Tapi tengok keadaan dululah macam mana. Kalau boleh saya nak terus masuk ke Maxim lah next week bersama-sama dengan reception tu. Okay, so tapi anyway, I see you next week, same time
Okay, doktor.
Thank you very much. And nanti Rachel, I will get in touch with you regarding the tutorials And then you all nanti you all keep in touch dengan your class rep lah pasal tutorial. Kita akan start next week.
Okay, doktor.
Okay. So thank you very much.
Thank you.
Okay,
Thank you, doktor.
Thank you, doktor.
Bye.
Terima kasih.
Thank you doktor. Stay safe.
Terima kasih, doktor.
Thank you, doktor. Thank you, doktor. Have a good day.
Doktor, boleh saya tanya soalan selingan?
Okey, apa boleh?
Minta
Siapa
maaf
yang
doktor.
Abu
Doktor,
Zafar?
Muzaffar. Minta maaf doktor. Jadi sekarang ni apa yang saya
Terus yang
faham.
lain tak jadi keluar.
Alamak, minta maaf. Tak apalah kalau nak keluar. Sekarang ni
keluar. Okey. Yang Abu
sekarang
Zafar.
ni apa yang saya faham, kita ada 2 set undang-undang. Kita ada satu je undang-undang in general, tapi dalam undang-undang tu ada 2 benda, which is common law dengan equity. Dan in general kita akan gunakan common law. Maksudnya undang-undang common law tu dah sedia ada, tapi bila mana kalau kita ada macam kelompongan ataupun kekurangan dekat mana-mana, equity yang akan masuk. Satu lagi fungsi dia adalah bila untuk mengelakkan ketidakadilan. Betul ke kefahaman saya setakat ni doktor?
Okey. Sekarang ni bila you cakap pasal tadi kan common law kan, equity tu kan. Bila you kata kita ni ada sekarang ni common law and equity. Kita tu you merujuk kepada Malaysia ke you merujuk kepada zaman dulu?
Zaman dulu.
Okey, kalau zaman dulu ya common law dan equity. Tapi kalau kita sekarang ni kita punya sistem, kita tak ada common law. Kan? Kat Malaysia ni tak ada. Ya, kalau you tengok balik section 3, kita punya application of common law and equity as at certain dates only. And we do not apply common law concepts yang as applied by the courts in England to date. Tak. Kan? Kita punya cut off date tu. Kalau you boleh recall balik MLS yang belajar dululah. So tapi kalau saya cakap balik sekarang ni, kalau macam tadi you kata dulu. Okay, kalau dulu memang dia dalam satu mahkamah dia ada common law, dia ada prinsip common law, dia ada prinsip equity. So bila mahkamah tu decide, okay, on certain issues, katalah you bring your matter to the family division lah, senang family matter. So you bring ni after Court of Judicature Act, so dia satu sistem. Okay, satu sistem. So you bring your matter to family court. And then bila you bring your matter to family court, so it's decided lah, katalah marriage ke divorce ke whatever. Okay. Then suddenly you nak dapat remedy, you want also equitable remedy. So you get equitable remedy. Itu ke soalan you? Apa soalan you tadi?
Ya doktor.
Itu ke? Bukan.
Ya. Waktu yang zaman dulu punya.
Okay.
Kalau sekarang maksudnya kiranya kalau sekarang ni kita ada undang-undang kita yang bertulis akta-akta semua tu dan disokong oleh equity lah kan doktor maksudnya?
Yes. Sekarang macam tu. Akta-akta kita, kalau kita ada akta, macam contoh kontrak, we have Contracts Act, kita ada National Land Code, kita ada Companies Act, kita ada State of Food, macam-macam lah akta kita kan. So kita ada provision bawah ada akta tersebut. Tapi sometimes certain provision tu are very rigid. In the sense that sometimes orang tu betul dah, tapi katalah kita ada parties A and B. If you follow the provision strictly, okay, it will cause grave injustice to one party. Contohnya lah because of the provision. So therefore masa tu court akan tengok everything lah, evidence, circumstances semua, and court akan decide kalau is equitable, then they will apply to the case.
Okey doktor, faham. Terima kasih.
Faham. Nanti kita tengok. Sebab saya tahu first lecture ni dia macam apa ni tak faham dua sistem semua. You all belajar pun selama ni tak ada dua sistem apa semua kan. Yes, memang betul. Saya nak bagi history sebab saya nak bagi tahu nature of equity tu. Tapi nanti bila you tengok case-case Maxim tu you akan faham. Oh, baru you nampak macam mana mahkamah tu akan step in to assist lah. Ya, Muzaffar?
Doktor, kalau macam kita kan ada undang-undang perbankan kan contohnya. Lepas tu kita pun ada perbankan Islam, jenayah kita ada jenayah Islam. Kalau equity ni dia ada yang Islam punya ke?
Tak ada.
Konsep tu tak ada kan?
Okay, konsep. Okay. Tadi saya cakap Roman kan. Okay, equity yang kita punya equity, okay lah saya kata kita punya equity ni sebab dia punya historical background dia is UK So kita pakai equity yang apply in Malaysia. Alright. Dia originate from equitable principle in UK. Tetapi kan tadi saya mention dalam one of the slide, in Roman law pun ada konsep equity. So basically it's the same. It's also equitable principle. It's not called equity, not a different division, tapi where the court or the judge apply justice. Tadi yang saya kata Plato. Tapi in Roman law, okay saya pun tak do research on equity in Roman law, tapi kalau you tengok saya note kat situ kan, in Roman law the judge, the presiding judge tu in one system dia dah memang apply the principle of justice. Okay, kalau in Islam pula kan, kita tak boleh, okay, kalau kita ikut history dia kalau ikut history, okay, kenapa equity means justice? Because the law is defective. In Islam, is a revealed knowledge, is not defective. Kita tak boleh kata is defective. Correct or not, Muzaffar? Islamic law, the first source, Quran Sunnah is not defective. Betul? Is wrong, salah. You cakap macam tu, kan? Tapi konsep kalau kita nak kata pemakaian, bukan betul lah, tapi a similar sense of the concept can be seen in later sources, secondary sources, not even the first main one. Kan kita ada Quran Sunnah, lepas tu kita ada yang 4 tu kan. Sorry ya, saya dah tak apa ingat dah saya punya Islamic. Yang 4 tu kan. Ijma', Qiyas, apa lagi 2
Istihsan, Masalih Mursalah.
Bukan yang 4 tu, yang bawah lagi pada 4 tu. Kan lepas tu ada banyak kan. Kan dia Quran Sunnah, lepas tu yang 4 tu, lepas tu after that there are others kan. Betul tak?
Betul.
So yang bawah tu kita boleh kita nak katakan itu mungkin macam, sebab itu adalah asas dia adalah juris kan, juris punya pendapat kan, dia punya reasoning kan. Tapi adalah salah kita kata itu equity, tidak salah. So kalau dalam Islam sebenarnya tak ada kalau kita nak ada analogi macam okey, macam mana kalau dalam Islam kalau kita nak tengok pun mungkin dari segi yang dari bawah-bawah tu. Bila dah sampai tahap juris punya pendapat tu. Okey.
Faham, maksudnya macam mana kalau contoh dalam hakim macam mana dia nak gunakan kaedah apa dalam Islam ni untuk mengelakkan ketidakadilan. Macam itulah, itulah konsep yang sama.
Dia peringkat bawah. Dia bukan peringkat atas. Okey?
Doktor, terima kasih banyak. Mak tanya soalan.
Nampak? Tadi kan you nampak anak saya tak?
Nampak.
Ya, saya nampak tak skrin saya. Saya ingatkan ni apa belakang ni. So saya macam panggil dia tu apa. Sorry ada interruption sikit. Okay. So okay. So thank you. So I see you next week for lecture and also tutorial Okay, saya boleh end meeting ya?
Okay, terima kasih doktor. Assalamualaikum.
Salam.